so thrilled that you could all virtually make it this morning to meet with me and talk about uncontested divorces. Throughout this presentation, if you have questions, please feel free to ask them. You can put them in the Q&A, and I will stop periodically if it seems like there's a lot of questions about a certain issue that you guys want to talk about. But I will also field questions at the end, so you can put them, as you have them. But I'll also be taking questions at the end, so if you feel like you'll remember, you can save them for that point, but feel free to put them in when you have them. Without further ado, let's launch right in. To start things off, I just wanted to talk a little bit about Her Justice and what kind of work that we do by sharing this video with you.
Caroline, don't forget to share your computer sound as well. When you change when you go to share screen.
Okay, new share.
And there's two boxes at the bottom that should give you the option to share computer sound and optimize for video.
Tell me if this works.
Mm-hmm.
Can you hear it?
Yep. Full screen it.
Pierce. And all I can remember is human life going in, and I held on for dear life.
Justice exists to serve women living in poverty in New York City. And our goal really is to stand with them by training volunteer attorneys to represent them for free in court cases and to address some of the systemic challenges that they face when they go to court.
From the day he moved out, he just turned his back on the kids, me, and just that was it. The house went into foreclosure and he lost the house. The fears was, I'm going to be homeless. I don't have anything to feed my kids.
If I had to say one thing Her Justice has done for the women that we have, it is to give them control over their decisions and a real sense that they deserve exactly what we've been provided.
My youngest two children, their father is an alcoholic. It became very verbally abusive and financially abusive. And then he also admitted to me that he had thoughts of killing us all, me and my children.
A lot of times in our clients' lives, there are a lot of intersecting issues. The current climate makes it even more urgent that we have quality-free legal services available because the stakes are much higher now.
I might be a drug addict 27 years ago, but I'm a different person right now. I just told me, don't do that.
Pro bono is really the lifeblood at Her Justice. We understand that while legal services organizations are essential, they never have enough attorneys to go around. So what pro bono does is take their desire to help and matches that with clients who really need that legal assistance.
In 2007, Laverne's former spouse tried to kill her while she was home with her children.
If it wasn't for them, I don't even know where I would be, probably homeless. Her Justice took care of that side of my life and gave me hope.
Laverne's case is resolved and is now precedent that is going to help other people in similar situations advocate for themselves.
I feel like I'm in a better place today. They stood with me. Made sure that oh, thank you, Her Justice. I went to Her Justice for help with my child support case. Before the lawyers came, he just never showed up. And when he doesn't show up, the judge takes it out on me as if I'm responsible for him. Once I went in there with a lawyer, the judge gave me respect. She didn't talk down to me back then, and now, night and day. If I didn't have Her Justice, I don't know where I would be.
Obtaining custody of my children was one of the best days of my life. Lawyers handheld me through the process, made sure that I was getting what I needed for the wanted. And without them, I don't know what place I would be in right now. It's very hard to put into words the difference it makes in your life. It's empowerment. It's claiming yourself again. Yeah, they gave me that back.
Rose's legal situation right now is looking very positive. We successfully proved to immigration that she had completely turned her life around despite all path to getting lawful permanent residence. status.
Had just changed my life. It given me hope. I'm very grateful.
The work of this organization is just as urgent today as it was 25 years ago. There are thousands of people who have come through the doors. They all give me hope because I know they are spreading the word that women deserve justice.
When I think back on our 25 years, I feel really proud that so many people have stood behind this organization and stood behind the women at Her Justice Fund.
I'm continually impressed by the amazing intelligence and commitment of the people and the services that they provide to their clients.
I was an extern for Her Justice. Know that you're going to have an absolutely profound impact on their life, and this will be the most important time of their life, and that you're the person that can get this. And without you, they might be taken advantage of by a court system that is really stacked up against them. It's rewarding, it's empowering, and it has been one of the best experiences.
I want to thank all of you who've supported Her Justice over the past 25 years. You can't imagine the difference it makes in the lives of our clients when you shift your power to them.
I still send my lawyers cards and thanking them because I appreciate them for what they did for me.
So our mission at Her Justice is to stand with women living in poverty in New York City by recruiting and mentoring volunteer lawyers to provide free legal services to help address individual and systemic legal barriers. Our objectives today are to understand a little bit more about the clients that you're going to be working with this summer, to understand the basics of uncontested divorces, including grounds and relief, to understand the relevant statutory provisions of matrimonial and civil procedure law, to get familiar with the necessary documents and filing procedures, especially now that things are a bit up in the air with COVID-19, and understanding specifics regarding things happening during the pandemic. In front of you, well, hopefully in front of you if you have a printer, otherwise digitally, you will have a copy of your UD manual. That is your Bible for this summer. You will find everything and anything you would like to know about uncontested divorce in that manual. It has been gone through with a fine tooth comb over and over and over again by Her Justice to make sure that any question you could possibly have is in that manual. It has samples of the kind of documents that you may need. It has samples of pretty much everything that an uncontested divorce could possibly ever have. And it also has some COVID-specific related things in the front there and some general knowledge stuff in the back. And we'll go through some of that more specifically as we go, but just make sure that you have that manual because that is going to be your guide throughout the summer. We operate on a pro bono first model, which was alluded to in the video. We always are incredibly grateful for the support that we get from firms like yours at any time, but especially during now, because our clients are more vulnerable than ever. I'm sure that you've heard on the news that domestic violence has been having an uptick. You can imagine that for our clients, many of whom are victims of intimate partner violence, dealing with the issues that they deal with on a day-to-day basis is always difficult, but during quarantine can be a lot more difficult, if not impossible, to navigate. And so the services of attorneys like you and firms like yours is nothing short of miraculous to them. And so we really, really appreciate the time that you're willing to give our clients, especially when they need it most, which is during these especially difficult times for everyone, but more difficult for our clients who are an especially vulnerable population. Most legal services organizations are one-to-one client lawyer ratio, right? The lawyer represents the client, they meet with them, they go to court with them, and that's why there's never really enough lawyers to go around. But we do a pro bono first model, which is that even though there's not very many of us at Her Justice. Right now there's 13 lawyers working very hard for our clients, but 13 lawyers couldn't possibly get the work done that we do every year, that we're able to get done because of your help. We mentored 1,804 legal volunteers last year, and we're able to serve 9,073 women and children, for a total of 76,400 donated hours. And those were hours donated by you and people like you, for which we're always incredibly grateful. That amount of money is valued at over $41 million. So you can see why this model, while it's not the way that most legal services organizations function, it definitely serves many, many more women than we would be able to serve with just the 13 of us working as hard as we can. So we are incredibly grateful for that help and support. Who we serve. Clients come to Her Justice through the Family Justice Centers in the 5 boroughs in New York City, and also our legal helpline every Thursday morning. Not this one for me. I got the morning off. Just kidding. They're taking messages and I'll call them back this afternoon. But every Thursday morning from 10 until 1, people call into our helpline. They speak with our legal assistants and our volunteers, and they get to speak with an attorney who can either provide them with advice and counsel, or who can talk to them about possibly putting them on the wait list to be placed with a lawyer like you, who will take their case in full representation and represent them from start to finish in whatever their legal matter is, from a family court to an immigration to a divorce case. We only have 2 requirements: that our clients identify as women, income that is below 200% of the federal poverty guideline. And now I would ask Mike to bring up our first poll. Oh, all right. So we got a little banter here. Looks like we're kind of split between A and B. I'll give you another couple of seconds to answer. All right, so it looks like about 55% of you got it right. The answer is $21,720 a year. For any of you living in New York City, you're probably laughing because that's crazy talk. No one in New York could ever live on that amount of money, because that's less than a year's worth of rent in any realistic place that you would, especially if you have kids, right? I mean, if you want to live in a studio in Bed-Stuy, even you're looking at like 900, 950, and that's like if it's a basement apartment, right? You couldn't possibly survive on that, even if you were one person. So if you have to have multiple bedrooms for children or anyone else living with you, let alone if you wanted to say like eat a sandwich from time to time. But that's the federal poverty guideline. So the reason that we have upped the amount from the federal poverty guideline to 200% of the federal poverty guideline is so that we can actually assist women who are within a living wage, right? What in New York City you could actually live on, which is about 200%. And even that is cutting it close. I mean, you're still scrimping and saving and probably not living in the way that you or I would consider a living wage. Our next question is, in the US, women are what percentage more likely to be living in poverty than men? Okay. So it looks like another bit of a split here between C and B. And the correct answer is B, 38%. I would love to say that it's sad that so many of you said C, but not incredibly shocking, because yes, almost 40% more likely to be living in poverty based solely on gender is an incredibly shocking statistic that I think kind of washes over a lot of us, even those of us that work in this field day in and day out. So a lot of the times, people ask Her Justice, why is it her justice? Why only her? Why do we only work for women? This poll explains exactly that. And I think that's kind of the only answer that we really need to give people, is that 40%. So our clients, we predominantly work with women in that, well, we only work with women in the 5 boroughs. It's unsurprising that most of our clients are women of color, given systemic racism. Obviously, the last couple of weeks have, I guess, pulled the shades back for anyone that was unclear about the way that our country feels about, people of color in this country, especially in the city. People of color are disproportionately living in poverty. It's also unsurprising that we have so many immigrant clients, given the barriers immigrants face to economic security, including language barriers, discrimination, aspects of the immigration system, and the current long delays in getting a work permit, which is something that we also do at Her Justice. COVID notwithstanding, the previous delays were also incredibly long, so it's not COVID specific. 55% of Her Justice clients were born outside of the United States of America, and 2 out of 5 of our clients can't access the legal system without an interpreter. We do not identify ourselves as a domestic violence organization, but it does happen that 75% of our clients are victims of intimate partner violence. This intimate partner violence wheel is been around for a while. It just clarifies what intimate partner violence is. It's a pattern. It's not one incident. It's a recurring abuse, and it's in any relationship used to gain or maintain power and control over another human being. That can be with coercion and threats, minimizing, denying, and blaming, use of children, use of male or immigration status as privilege, or economic abuse. And the abuse can be physical, emotional, sexual, or financial. We have been discussing a lot recently the "why doesn't she just leave" myth. It has been discussed a lot in media and in TV programming and films. We are not the feminism of Lifetime movies anymore, so it is a lot less common to hear "why isn't she just leaving," but it is still a common narrative that Her Justice works and actively fights against, to understand why women in intimate partner violence situations aren't leaving those situations. The power over the victim is often so pervasive, either through economic control or threats to break up the family or threats against family. We have a lot of clients that have family overseas, in other countries, where the abuser will threaten their immediate family overseas, and will use any mechanism of control that they can to keep that victim in a subordinate position. The reason that we talk about this is because we want you to understand that it's a very real possibility that your client will be a victim of trauma, Trauma results from an event or a series of events that is experienced by an individual as physically or emotionally harmful or threatening, and that has lasting adverse effects on the individual's functioning and physical, emotional, or spiritual well-being. It's important that you understand what trauma is and that your client may have experienced it, because you may have to deal with the impact of that trauma on your client when going through her divorce. Impact may be that she has difficulty recalling certain situations that she may need to. A lot of times clients will need a confidentiality motion, and they will need to recount the reason that they need to keep their address confidential. They may not remember specific moments. And this is just a poll to make sure that you're still here with me. So just click in if you have that poll in. You may not understand or recall exactly what date things happened or what time or where she was when things happened. And that's because the brain can do a lot of really interesting things when it's been subjected to trauma. And it can delete certain things to protect the person that has been a victim of that trauma. You are not meant to be psychologists. You are not meant to be psychiatrists, and it's not your job to assist your client in dealing with that trauma. If you feel like your client needs additional support, like therapy or a social worker, there are additional resources that we can help you with. And if you look in your handy dandy manual that I will continue referencing throughout this training, because again, it is your Bible, there are resources and referrals on pages Roman numeral 4 through 6 that will give you additional resources that your client can reach out to for therapy, for social work, for meditation, for yoga, anything that you think might help her or that she might be interested in. And also you can contact your Her Justice mentor. We have additional resources that might be able to help. Working with trauma survivors. The most important thing is to be humble, right? To understand that there's a lot of things going on with your client that you may not understand, and you don't have to. And it's not your job to understand. It's not your job to give therapy or give advice or help or fix or do any of those things. Your only job is as a legal representative. And as a legal representative, you need to get the legal facts that will be necessary in order to get her divorced. That being said, in order to get those legal facts, you will have to possibly wade through some things that will be difficult for her to talk about, if not reliving some of her trauma. So just make sure that you're patient, that you are non-judgmental, that if there are things that she talks about that she seems uncomfortable with, or if it seems like she's hiding things, she may be, she may not be, it doesn't matter, and it's not your place to judge. You are to go in there as if your client is telling you exactly what you need to know, and you are to go based on those facts and those facts alone. That is your only job as her legal representative, is to zealously advocate for her. And I have no doubt in my mind that that is 100% what everybody in this virtual room wants to do. So with that in mind, just make sure that, you know, that's something that you're mindful of. And something else that you need to be mindful of, especially, and you know, even those of us that have been doing this work for a long time, we can forget to take care of ourselves. We can forget to eat food sometimes, or drink water. We can forget to, you know, take a shower, or, you know, go outside every now and again, especially when you're working from home. You forget to switch on and off at the beginning and end of a day, because all day, sorry, I live in New York. I hope that wasn't distracting. So just make sure that your day has a beginning and an ending, that it has meals in it, that it involves you switching on and off, that involves you caring for yourself both physically and emotionally, and that if you need to meditate in the middle of the day, if you need to take breaks, that you're doing that for yourself. You are also important, and there is something called vicarious trauma that can impact even the grittiest and oldest of soldiers that do this kind of work. So that's something to be mindful of also. If you need assistance or resources about that, your Her Justice mentor can absolutely help you. And there are a lot of people that we know that can help you. There are a lot of free resources right now, especially during this time, that we can refer you to, and that can be really helpful. There's like a million webinars on mindfulness and yoga, and or if that's not your thing and it's just like you want to punch stuff, whatever your jam is, like we have resources to help. So make sure you're taking care of yourself. And that's not to say like you're going to meet this person and suddenly like fall apart. I'm just saying if you need that help, know that it's there. Don't think that just because you're working from home that this will be less stressful than if you were doing it in an office setting. Also, this video at the end, we don't have time to show it today, but if you want help or want more resources on working with victims of intimate partner violence, this is a good resource to take advantage of. So we will have the slides. I think you have them in a PDF. So make sure you watch it if you want more information on working with victims of intimate partner violence. Okay, intimate partner violence and your case. Obviously, it's a tricky aspect of your case, but it doesn't have to be that tricky. Mostly, it will not come up. Sorry. Yeah. On your client, and as I said, just make sure you're giving your client space and room. On that same note, know that your client may have differing ways that she wants to respond to that trauma. Leave space for that. She may be angry and yell a lot, or she may cry a lot. There is no rush. Make sure that when you schedule your initial appointment with your client, leave some time for it. It may take longer than you think. If it doesn't, great. Then you have an extra hour in the day to do something else. Go take a walk. But leave a couple of hours instead of scheduling it very tight in a block so that you can have time in case you need it. All right, remote working. Your client has different access to stuff than you, right? You are working for firms that have a lot of resources. Your client has zero resources. So if your client is tech savvy, and she very well may be, she may have Zoom, she may have Google Chat, she may have this, that, and the other. She may have kids that have those things that can set her up with all that stuff, and she may want to do all that and be totally down for it, ready for, whatever tech, whatever. She may be 70 and want to write you a letter. And that's not a joke. I have had that client only wanted to write letters. Just meet your client where she is. Know that different clients have different resources. They want different things, and they want to get different things from their lawyer. So your job as this woman's advocate is to meet her where she is. And if what she wants out of this advocacy is to speak with you once a week, great. If she wants to speak with you twice over this entire representation, great. If she wants to speak with you like once every 2 days, you might have to like give her a bit of pushback, but within reason, let her dictate the terms and let her dictate what those terms are. If she only wants to talk on the phone and she doesn't feel comfortable because maybe she lives in a studio and there's like 7 other people living in there and she doesn't want to like deal with you seeing her home. You know, maybe she's embarrassed, or she doesn't want you seeing who she lives with, or maybe her abuser's in the home, or, you know, there's a whole host of reasons why she might not want to do video stuff. Don't press it, you know, I mean, kind of make sure that it's her that's dictating the terms of this, and try and be as understanding as you can. Know that, you know, our clients are the most vulnerable population here, and obviously it would be contact that you could, but know that, you know, our clients are disadvantaged in a lot of ways, and so just try and be understanding about those things as much as you can. Again, with self-care, we're going to harp on it over and over and over again because it's important, and it's something that a lot of people don't think about. Make sure that you're taking breaks. If the client needs breaks, take breaks. You know, I mean, my computer overheats like once an hour because I bought it on Black Friday for like $2. So I will literally get like kicked off of meetings all the time, and that's something I just have to deal with, and so do my clients. Those tech things are going to happen. Be patient with your client, be patient with yourself. If your firm has access to FaceTime and you're on a work phone and you feel comfortable doing that, great. If you don't want to do it because you don't want, you know, that's a very personal thing, your client doesn't want to do it, like, don't do it. You know, like, whatever everybody feels comfortable with, that's the way to go. If you can do, you know, video, great. If you can't, also fine. There is stuff in the manual, again, pages 4 through 6 in your manual. Go through those couple of pages. If you have more questions about that, feel free to talk to your mentor. Your relationship dynamics, make sure that you set good boundaries, right? Our clients sometimes work at night, sometimes they work overnight, sometimes they aren't working, so they don't really have a schedule, they don't really understand the concept of 9 to 5. Setting boundaries is always good at the get, right? So my clients know they don't have my cell phone number, I'm not available after 6 p.m., I don't work on weekends. It's okay to set boundaries, right? It's important to meet them where they are, but it's also important to make sure that they know what your schedule is. So if they're emailing, calling, it's 9, 10 o'clock at night, don't respond then. You don't have to. That's not your job. Make sure that they know what your boundaries are. You know what their boundaries are. That's the best way in any relationship to make sure that both people understand how you're moving forward, right? So even if you have free time, and this happens to me all the time, even if you just like get the email and you're cooking dinner and you're like, well, I could just, no, don't do it, because once you set that precedent, now you're on the hook. Every day at 7 p.m., you're going to have to answer that email. So just don't set that boundary early on. Make sure your client knows, and make sure you stick with it throughout the summer. Organize the case and make sure you're telling her what you're doing. Communication is key in these relationships, right? So even if you do something that's like dumb and it's like, oh, I sent the thing to the husband or whatever, because 9 times out of 10, the reason that clients get frustrated with attorneys is that they're not communicating. So just make sure if you're sending something to the husband, or you sent a draft to me or whoever your mentor is, just let her know. Like, I sent this over for finalization. I'm waiting on the result, and once I get it, I will send it to blah. Just, you know, make sure you're communicating with her, letting her know where you're at. Also understand, we get that this is not your area of expertise, right? This is probably the first one of these you've ever done. We don't expect you to be an expert. We're the experts. So we are here for you. We're ready. You know, we are here to field your questions, to talk to you. If you want to have phone calls, if you want to have conference calls, if there's any time that you don't feel comfortable, or you feel like there's a rift with the client, or you can't get a hold of the client, or there's some problem in the communication there, that's what we're here for. So make sure to reach out. Resources for you, manual. Just going to keep harping on it. It's in there. There's some resources for you, resources for your client. and not just like mental health resources, like free lunches and food resources, clothing resources, shelter resources, all kinds of stuff in that manual. So make sure you look those up. All right, let's see where we are here. Matrimonial law. Now that we are done with our objectives. Let's get to the meat. So, for those of you that don't know me, and I think most of you don't, matrimonial law is by far the most fun and exciting area of law in all of law. This is not a joke. It is so awesome. It will blow your mind. Uncontested divorces, granted, can be slightly dry, but the actual ins and outs of divorcing people are so juicy and so fun. You basically get to like hear the most intimate and detailed emotional parts of people's lives every day, and then you get to help them get out of it. It's so rewarding, it's so exciting, and every single divorce that I've ever done, I think that the reason that they always send me to do these trainings is because while most people kind of think of uncontested divorces as like, well, it's all paperwork and like usually, you know, like they don't send the litigators in to do uncontested divorces. As someone that has litigated for a decade, I still love uncontested divorces, even though it is all paperwork, because the juice is still in there. The people still had this marriage together. They still met at some point and fell in love, and maybe or had kids or didn't. They still have like a history together, and they still had a life together, and you get to hear all of that life and why they're divorcing now. So just don't take for granted the fact that like, yeah, it's a divorce and it's just paperwork, but to your client, this is the biggest thing that's ever happened to them, and you are taking them out of something that probably broke their heart. So if you go into it looking at it that way, it makes it much more fulfilling and it makes the work much less dry. And I say that all because now let me tell you some wildly dry things for like an hour. But you need to pay attention because this is what you need to know to do an uncontested divorce. Okay, so focus in. Matrimonial law. Jurisdiction and venue. Jurisdiction, everybody knows, right? Law school. You need jurisdiction in order to file in New York City. Normally, we file everything in Manhattan County. The reason for that is because Manhattan is 5 times faster than any other borough. Pardon me. But I say that with a caveat because now everything's e-filed. So I don't know the answer. Normally, I would say yes, Manhattan. File at Manhattan, 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 Manhattan. I don't know. E-filing, it might just be easier to file it wherever your client lives. I don't know. Talk to your mentor about it. I would say default to wherever your client lives unless you feel like you want to file in Manhattan. The reason we usually file in Manhattan is because all of your firms are in Manhattan, and it's easier for your managing clerk to go and file papers downtown, right, than to go because it's a debacle and no one wants to do it. So we usually file based on 509 because why not? And then you can file in Manhattan. But right now, because everything's all virtual, I don't really see any benefit in filing anywhere else. And also I worry a bit about the fact that maybe Manhattan will be like, why are you not filing where the plaintiff resides? Because that's the normal reason for a venue, right? But I don't know. So talk to your mentor about it. I guess I would say file where the plaintiff lives, unless you have a reason to file in Manhattan. Talk to your mentor. Yeah, I would go with that. I think I had one other thing to say about jurisdiction. Oh, residency requirements. Yes. So 90% of your clients, the residency requirements for jurisdiction are going to be that she has lived in New York for more than 2 years. Some of them will not have lived in New York for more than 2 years. And in that case, you need two things: that she's lived in New York for 1 year and one other thing. So either the marriage took place in New York, the marriage broke down in New York, or something else. It'll probably be that the marriage took place in New York. But if she hasn't lived in New York for 2 years, talk to your mentor about that, because you won't be able to use that as a grounds for residency. Your grounds are always going to be DRL 170 subsection 7. That's New York State's no-fault grounds. That is that the relationship is broken down irretrievably for a period of 6 months prior to the commencement of the action. In the old days, there were other grounds, and actually New York State was one of the last states to get rid of grounds. So for those of you that have taken family law or domestic relations law, you will know that there are other grounds in New York State, such as cruel and inhuman treatment or abandonment or infidelity, and that us oldies used to have to prove those grounds in what was called a grounds trial, where you would have to put your client on the stand and they would have to testify in open court about their partner cheating on them, and how you would have to like introduce photographs of the infidelity or of the abuse or whatever it was in order to prove those grounds. And if you couldn't prove the grounds, the judge would deny the divorce and the parties would have to stay married. That used to happen in New York State. But then a long time ago, we got, not so long, but a while back, we got no-fault grounds finally. And now everybody does no-fault grounds. There's no reason to have grounds ever for any reason. If your client wants grounds, which may be because she's a victim of domestic violence, and she wants people to know that she was injured, that her partner hurt her, and that's legit, and those are her feelings, you need to have a conversation with her about why it's unnecessary to have a grounds trial. It takes a long time, and it's in a case like an uncontested divorce where there is no other outstanding issue, there's no equitable distribution, there's no maintenance, there's nothing else to fight about. Having grounds in a summons and serving it on the husband will make him contest the divorce. And having the only issue outstanding being those grounds is a way to make a very quick and easy divorce a very long and difficult divorce. So that's a conversation that you'll need to have with your client about why we don't use grounds, even if there are legitimate grounds that we couldn't prove. Ancillary relief. So the ancillary relief in an uncontested divorce. If there are children, you have two options for custody. Either there is no prior family court order. If there is no prior family court order, that means that you will be listing your client as having sole legal and residential custody, and you will be saying that the father, and at this point I would like to just interject and say that I say the father, that's not because I am ignorant to pronouns, it's because I believe that all of the cases that we have this summer are male-female relationships. If that's not true and you have a same-sex couple, pardon me, but I'm pretty certain that it's all male-female relationships this summer for our summer associate program cases. So if that's not the case, obviously it'll be that the wife shall have sole custody and that the other wife shall have reasonable visitation. But in the most predominant cases, it'll be that the wife shall have sole legal and residential custody, and the husband shall have visitation with the children as the parties shall mutually agree. I'm going to say that 4 or 5 more times in this training, and I guarantee you that there will be at least 4 or 5 of you that will still send the papers in without that language. Our software does not put that language in, because basically makes it so that your client dictates the terms of that visitation. No visitation gets through without your client saying it's okay, and that's what we want. So we changed it. As the parties shall mutually agree basically means if she says no, it's not happening. And the courts have not pushed back on that language yet. They may, but they haven't at this point. So that's the language we're using at the moment. Child support. Child support has to be listed in every single document, in your summons, in your complaint, in your findings of fact, in your judgment of divorce. It has to be in every single document. If it is not listed, it will be kicked back by the courts. The courts will not accept a judgment of divorce if child support's not mentioned. If your client says, I don't need it, I don't want it, I don't want anything to do with this man, I don't care, he's not going to pay it anyway, he's a deadbeat, too bad. You have to list it because the court will reject the papers without it. That being said, the court, in its infinite wisdom, has decided that the de minimis amount of child support in New York State is $25 per month. So if there is no prior family court order, your client, who we have already spoken to, will be accepting the de minimis amount of $25 per month in child support. What does $25 a month in child support buy you? I will leave that for you to discuss on your own, but it has to be listed no matter what. So if your client doesn't have a prior family court order, list $25 per month, always through the support collection unit. We'll talk more about that later on. Other ancillary relief is health insurance for the child. You have to list health insurance for the child. Usually your client will have the child already insured either through Child Health Plus or Medicaid. You will need to get that information from your client. That's including the ID number and all of that information. So if it's like a Medicaid card that she has, make sure that you're getting all of those numbers on that card because you have to list them in the papers. If dad is the insurer, you need his insurance information. Whoever is the insured, you need that information for the papers. Continuation of prior court orders. If there is a prior order of custody or visitation, all of the language needs to track the language in that family court order. So the language will say something like, pursuant to family court order in Bronx Family Court dated February 7th, 2019 under docket number F01719, father shall pay child support in the amount of $171 per week to the support collection unit. Something like that. The language has to be exactly what it says in the court order. The same goes for if it's a custody and visitation order. Whatever the language is in that order, that's what you put in your papers. And if your client has prior orders, we will be providing them to you. Just a note, for your final submission of papers to the Supreme Court, you will need a certified copy of any prior family court orders. You can't get it. The family court is closed until further notice. It's only hearing emergency applications right now, and it has, I think, 3 virtual parts open right now, and that's for orders of protection and emergency applications. That means you can't go to the record room in family court and pick up certified copies. So What that means for you is that if your client doesn't have a certified copy right now, you have one of two options. You can either try and e-file, because you're e-filing anyway, right? So if you e-file your documents, you could try and e-file the not certified copy and see if the court takes it, which they may. Or you can wait until the family court reopens and try and get a certified copy. In real life, in non-COVID world, the court rejects any papers that come in without a certified copy. Since the court just opened to e-filing, I have no idea whether or not they'll reject it without a certified copy now. So that's a trial and error thing that you guys can be the guinea pigs for. Other ancillary relief, concurrent jurisdiction. New York State, in its infinite wisdom, has two courts that do the exact same thing. The Family Court and the Supreme Court both decide issues of child support and custody. Why, you ask? Your guess is as good as mine. Divorce actions in Supreme Court will decide custody and child support. Family Court also decides child support and custody. So in your papers, you need to list that both courts will have concurrent jurisdiction, that the Supreme Court will have concurrent jurisdiction with the Family Court, so that after the judgment is issued, that your client can go back to Family Court in case she wants to change anything. And at this time, it looks like Mike is giving me the signal that you need to write this down. The password is BX718. BX718. And one final note on concurrent jurisdiction. The reason that we put that language in is not only because the court will kick the papers back if you don't put it in, but also because there are filing fees in Supreme Court and they're hefty. All told, an uncontested divorce costs more than $500 just in filing fees in Supreme Court. So you don't want your client to be on the hook for that money if she has to go back later on and change something. If right now she's on, say, public assistance and doesn't have standing to get child support, but later on she gets a job and she wants to go get child support, she can go back to Family Court and do it. It's free to file there. So you don't want to keep her on the hook to go back to Supreme Court because she'll have to pay a bunch of money to do it. So make sure you put both courts to have concurrent jurisdiction. And finally, use of prior surname. You definitely want to put this information in. Your client will say, I never changed my surname. I don't need to change it back. On her marriage certificate, it will say both names. It'll say her maiden name and her married name. She may never think that she changed it. Her driver's license may not have it. Put it in there anyway. Put it in there anyway. Just do it. Trust me on this. If she doesn't do it, and later on she needs that like fancy, whatever that's called, the new ID that you have to have, they won't let you do it because your marriage certificate says a different thing. And I know that just because my sister did it, but also just do it because it says it on your marriage license. They won't let you do it. Just put her prior surname in, say resume use of prior surname. It'll save you a headache later. The reason we put the contested relief in there is because if your client's asking for any of this stuff, you can't represent her. So if she's asking for joint custody, you can't do it. The court can't award joint custody. The parties have to agree to it. So if you have a custody trial, after that custody trial, the court can't award joint legal custody. The court can only award sole custody. The parties have to agree on joint legal custody, so you can't ask for that in an uncontested divorce. Maintenance, which is New York's version of alimony. If she wants it, that's not an uncontested divorce anymore because oddly, no one in their right mind ever disagrees to that. Health insurance for the client. If she's on her husband's insurance and she wants to keep it, too bad. She's going to get automatically booted off within 30 days of that judgment of divorce. Equitable distribution of assets. They have a home in Guam. They have a home in Guatemala. They have a home in Puerto Rico. She wants half of it. Can't distribute it. He has retirement assets. He has a pension. Can't distribute it. If she wants anything in terms of asset distribution, it's no longer an uncontested divorce. We can't do it. Exclusive together. If they're on the lease together for another 3 years and she wants him to get out, not an uncontested divorce anymore. So if your client brings up any of these things as issues, immediately talk to your Her Justice mentor. We'll go through it with you. Your client should have been screened for any of these things. There shouldn't be any of these things in your cases. If it does come up, make sure you get in contact with us as soon as you can. A note, in your manual, there is an intake form. When you talk to your client for the first time, you'll go through this intake. It's a long form intake at the back of your manual. I can't remember what page it's on. But that's the thing that you're going to be using the first time you meet with your client, right? Hang on. I think it's on page 139. I think it starts on page 139. And that's in the, you guys might have different ones if you have kids and if you don't. But if you have kids, it starts on 139. That long form intake asks a bunch of questions about these things. It says, you know, do you want this stuff? And ask anyone in New York, anyone in the world, do you want extra money? They're going to be like, obviously, yes, that would be fantastic. I will take some maintenance. So when you're framing those questions with your client, just make sure, don't ask it like that. You know what I mean? Don't be like, do you want maintenance? Because of course, yes. We've screened out those things, and based on either what they told us, they don't know how much the husband makes, or he's unemployed, or he bounces around and, you know, he never has work for more than 5 minutes, or it's like a 1-year-long marriage and they're not entitled to it. We've considered these things, and when, you know, taking them on as an uncontested divorce, we would never take a client on that was entitled to stuff and been like, no, yeah, go ahead with an uncontested divorce. So like, if they are now saying like, oh, we want these things, either they're not entitled to them or we've gone through it with them. So when you're going through the long form intake with them, just make sure you're kind of framing things in such a way that like they understand that probably they're not entitled to these things. If they seem like they are entitled to them, or like there's some piece of information that we missed, like I think he has $100,000 in a pension, obviously like bring that up to us, but usually we will have screened for it. So just something to note. Other ancillary relief, continuing the family court order, obviously, or sole custody of the client, as we discussed, and visitation to the spouse. Again, as parties shall mutually agree. I'm going to keep saying it over and over again. Hopefully you guys will remember. If another poll for you guys, everybody still watching? If the kids are under 18, you need one of 3 things, right? One of 2 things. Either you're continuing the family court order or it's going to be sole custody to mom, reasonable visitation to dad, which is as parties shall mutually agree. 3rd time's the charm. Child support. Which is fine. Or if you are, you just have to put that language in, track the language from the family court order. Or you're going to use the worksheet, which is a trick. And if that's what you're doing, just ask for help. It's math. And as lawyers, we all hate math, right? But we can get through this together. I promise you, we will be there for you every step of the way. Like, it is annoying. Everybody hates calculating child support. It spits out like random different answers based on who's doing it, and the worksheet is like not helpful at all. But you know, we're here. So if you're doing it based on the worksheet, and the only reason you would be is because we have income for both people, right? Like we have mom's income, we have dad's income. They're both W-2 employees. All we have to do is crunch the numbers, figure out what it is, and figure out that number, right? And if that's the case, we can do it. There are samples in your manual of that worksheet, but it's also just confusing with the sample. So if you have that situation, just make sure you're in touch with your mentor. Oh, one thing I want to say, and I'm owing because I want you to really take this in. I didn't say this at the beginning, and it's very, very important. This summer is a different summer for us. We usually have one mentor per team. This summer, we're doing it as partners. So you'll have 2 mentors for every team. That's because a lot of your summers are shortened. You guys are doing it, a lot of your firms are having shorter or longer or, you know, different summers. It's a weird summer for everybody, right? It's virtual, we're doing it in a different way. So you have 2 mentors. So make sure that when you get those emails about who your client is, you'll have 2 mentors on that email. Every email that you send about your client to your mentor, make sure both of those people are on that email. And the reason is because we'll be on vacation, we're doing this and that. Some of us are doing one thing or another thing. Make sure that both of those people are on every single email so that you can get the quickest response that you can. Because one of us may have more time than the other or maybe away, but we're working in teams this summer. So just, that's something important to note. And I really didn't want to forget to say it. So teams, make sure you're emailing both of us. Sorry, back to child support. As we said, the de minimis is $25. If there's no prior order and there's no W-2, you're going to be doing the de minimis. It's always through SCU if there's no prior order. Usually if there's a prior order, that will also be through SCU. SCU stands for the Support Collection Unit, and their job, if the father is a W-2 employee or if he gets a paycheck, the child support will be automatically taken out before he even gets that paycheck and given to mom. So we do everything through them because it ensures that they get that money more efficiently and doesn't rely on dad to pay at will. Okay, poll number 2. Will a judgment of divorce be granted without addressing the issue of child support? What do we think? Nice. I'm so excited to see you guys. We're paying such close attention. That's correct. If you do not address child support at all, the judgment will not be granted. So you have to address it one way or another. Even if your client says she doesn't need it, you have to say at least the de minimis amount or it will be rejected by the court. 88% of you. Well played.
Caroline, you do have a question in the Q&A. Would you like to respond to it now? So Caroline will answer it verbally and I will type her answer for her.
Oh, sorry. What is it?
The question is, what makes someone entitled to maintenance? From David Simpson.
Okay, so maintenance is New York's version of alimony. The biggest factor in determining whether or not you're entitled to it is the duration of the marriage and the disparity in income between the parties. So a typical maintenance situation is mom is a stay-at-home mom and dad is the only outside of the home working person. And so because he makes most of the money or all of the money and the marriage is long-term, she'll be entitled to maintenance. So cases where I fight for maintenance generally are where like dad's an investment banker and mom's been home for 20 years and they've been married for 20 years, like that's a bank case. If you're, now that I work at not-for-profit land, I don't really, call it a bank case anymore. But when I was working in private practice, you want to have the wife in those kind of cases, because if the husband has been working outside the home and the wife has never worked outside the home, the duration and amount of maintenance will be in direct relationship to how long the marriage is and what the difference is in their incomes. So like if both people are working, for instance, and like he makes 60 and she makes 40 and they've been married for 6 years, probably no dice. But if it's 20 years and he makes 100 and she makes 0, that's a maintenance case. So usually that. But other factors include like age and health of the parties, like if one person's sick or on disability and the other person's working, or one person's old and the other person's young, like those cases where, the old dude marries some young thing, those are maintenance cases usually. But generally in New York, the cases where you see maintenance the most is where it's a long-term marriage. The longer the marriage, the longer the duration. Usually it's between a third and half of the marriage. So any marriage that's less than like 3 to 5 years, we don't even really talk about it much. The cases where you see it most are those long-term marriages. That answer that question?
Yes, I just typed out your answer the best I could.
Okay, great. All right, so moving right along, we are at other ancillary relief, health insurance until kids are 21. Other states have other rules, but for New York, you have to insure your kid until they're 21. So just note that will have to be stated in your papers, that whoever is insuring the child will have to do it until the child's 21. You can have a pro rata share of certain other costs for the children, and that would be things like camp or daycare or babysitting expenses, stuff like that. Usually cases that have that pro rata share are cases where both parties are working, and our cases usually don't have that information. If our clients that qualify for our services don't have a pro rata share, so you won't have to worry about that, but it can be listed if both parties are working and they have similar incomes and they need to divide it up. So like if one party is making 80,000, the other party is making 40,000, they will both put into those things in their pro rata share. Again, concurrent jurisdiction, just a reminder, make sure you put that in, and use of prior surname, also put that in. All right, working with your Her Justice mentor. Okay, so as I said, this is a weird summer, right? And so we are weird, and so are you. Everything about it is a bit weird, and you have to give yourself some space for that and give us some space for it as well. Normally, we do things very linearly. I give you a timeline, like this is when things need to be done. We need initials by this date. We are going to come into your office on this date. We're going to do a boot camp on this date. You need to have this stuff done. Make sure your client meets with you by this time. Whatever. This year is like, because your firms have different timelines for you and you have different timelines for yourself. Some of you have shorter programs, some of you have longer programs, and we want to make sure that you're giving yourself enough space that you're not just like up to your eyeballs in work at any given time. You're not overwhelmed, but also that you're not like dumping a bunch of stuff on the associates when you leave at the end of the summer. So it's going to have to be very case by case, and we want to make sure that you are getting your best summer experience also. So with all that being said, our plan is, hopefully, again, we're going to have 2 mentors for you this summer. So we are going to be as available as possible for you more so than we have been in past summers, so that we can get your things reviewed as quickly as we can. We normally ask you for as much time as you can give us to review your documents, because obviously we're a lot less than you are, and we need time to go through things. So please don't send us things and then ask for them back the same day. If you're going to have a call with your client, please don't ask for, you know, tips when you're calling them in an hour, that sort of thing. Be conscious that we are, you know, individuals as well. But that being said, there are, you know, 2 of us this year, so we're going to try and be as available as we can, but also just, you know, be thoughtful of us. That said, the thing this summer I think is going to be to get as much drafted as you can, which includes both initials and finals. Generally, we say the goal is to have your initials, to meet with your client, right? To have your initials drafted, and then get your finals done if you can by the end of the summer. If not, okay. But, you know, we ideally would like you to have these done. Now, because you're e-filing, we're leaning towards saying we'd rather you just have this entire pack. When you leave, even if it hasn't been filed or served or anything, when you leave, your firms will have this whole packet that they can work with, so that when courts reopen, if they want to just do it as a hard filing, they'll have it. That being said, if you are in a 10-week program and your firm says, no, we want to do it like a regular summer, go ahead and e-file it. We're going to serve it. We're going to do it like regular. Fantastic. We are happy to do that with you as well. Do it like a normal summer. Do the service. We'll wait, review the finals after you've gotten your stuff back. That's fine. So again, you know, it's going to have to be on a case-by-case basis. Know that we are here and we're happy to discuss with you whatever options you want to do on a firm-by-firm basis, on a case-by-case basis, shorter, longer, whatever your summer is. So working with your mentor this summer is going to be a little bit different than it usually is. But we have had just nothing but great experiences working with you guys in the past, and I know it's going to be amazing, just like it is every summer, and I hope that you guys will feel the same way. So, managing your case. This is where all the questions are going to be, right? I am going to answer these to the best of my ability, but know that this started like 2 weeks ago. So, as an expert, my knowledge is also quite limited. So I will do my best to answer all of your questions about what's happening right now. But know that I also don't know everything, because this is bonkers, right? So NICEF is e-filing. That's where you're going to file your initial documents right now. The court is not open. It's not physically open. The Supreme Court's not physically open. Judges went back into chambers yesterday for the first time. Is that an indication that they will be reopening for hard filing? Your guess is as good as mine. There are rumblings that perhaps that may be something happening in the future. Will it happen during your summer? I don't know. Is it a waste of time to get an NICEF e-filing account, do all of this work with all this e-filing garbage, and then surprise, the court reopens? Maybe. I don't know. I can't tell you that information. It's going to have to be up to your discretion, right? If you want to e-file it because you want to, I mean, it's an experience, right? Like, you'll learn how to e-file, so that's exciting. You can get a NICEF e-filing number. That's also exciting, I guess. Give it a shot. Once that case has been e-filed, you have to serve the defendant with a consent. So where you normally will serve him with the summons and your cover letter to him, you now have to serve him with this consent. You're out of luck. So if he signs the affidavit of defendant, he consents to the divorce, everything else is like great, good, wonderful, but he doesn't sign that consent, no, you can't, because you have to have his consent in order to make it an e-filing case. If he defaults, right, if he doesn't answer the papers, it's not an e-file case, because you have to have that consent. So Is it better to just wait and do it as a hard filing? Again, these are things that you just have to think about. I don't know the answer, but that's why we're saying this summer specifically, draft all the documents, get all the documents drafted, because the filing part and all that stuff, it's going to have to be kind of, what do you think? Because I'm not sure if it's better to just e-file it, serve the guy, see if he signs the consent, and then do it as an e-file case. Because once it's e-filed, then you have to do everything e-filed, right? You can't go back to hard copy after that. So if the courts reopen and you want to do your files, you can't have your managing clerk's office go down there and file those things. You're going to have to do everything e-file after that, right? So like, just things to consider. Discuss it with your mentor. Specific e-filing things. You have this additional paper that I just sent you yesterday because we just made it yesterday. These are things as of June 8th, right? As of May 25th. E-filing for both contested and uncontested divorces. That's how you do it. There's this website here where you go and do it. If you want your own NICEF, if you're a lawyer, you have to be a lawyer. All you need is your, whatever that ID thing is, your attorney ID number. Whoever is going to be the one that signs these papers, they can get their own NICEF number. Or if your firm just has one, like universal one, that's fine. You can use that one too. But again, you're going to need that consent from the defendant. Know that you're going to need that consent. So yeah, and that consent is, I think, on this. Okay, so these are the pages, 4 to 6. This is in the manual, and then you have that one additional page that I also sent, that Mike sent you guys yesterday. Not yet, not yet. Sorry, I didn't mean to jump the gun. Let me just give you a couple more things about COVID-specific stuff. So that's nice stuff. E-notarization. Your client needs to sign certain documents. Right now, because of COVID, you can do it on video. So they're on this extra page that Mike sent out, I think yesterday. There's instructions for and you would do regular notary, you have to say that it's through video. But basically, as long as as long as you can see the person, you know it's who they say they are, and they can hold up their ID and stuff to show you who they are. You can do it through video. They don't need to physically be in your presence to do it that way. So, for instance, the complaint that your client will need to sign, you can do it that way. So the instructions are there on that extra page. Anybody have any specific questions before we break about COVID-specific e-filing stuff or changes in the summer program regarding your mentor and your relationship with her justice mentoring or anything like that before we break?
Also, I understand, I've been following in the chat that a few of you have not been able to use the polling or Q&A features, which are part of this webinar. We apologize for any issues that may be coming up. Like I said in the chat, if you have any questions, please submit them via chat, and I'll be sure to relay them to Caroline. And we will also note that if you were seeing any issues with attendance, we'll be sure to make a note of that as well. Like I said, my apologies. It may be an issue if you're trying to connect via remote desktop. That might limit your accessibility, and then it also might be an issue with having an outdated Zoom. But for now, just attend the webinar, and like I said, submit any questions you might have via chat if you cannot use the Q&A. Again, Q&A is preferred. Thank you very much.
Okay, so we're just going to take a break for about 7 minutes. So come back at 11:30 and we will resume. Okay, guys, welcome back. Hope you had a nice little break. So we're going to dive back in with drafting. Now, this is the portion that is the meat and bones, right? So this is the part that you're going to want to make sure that you're really dialed into, because this is the part that you're going to need to actually draft. Normally in these presentations, I go through drafting libraries with you, but for today's, I'm not able to do that. So that means that you're going to be on your own with drafting libraries. Most of your firms have that. If you don't, you have the samples in the manual. Once again, shout out to the manual. And you can use those as samples. We can also send you samples if you need them. So your initial documents, your sample sets. Look in your manual now. On 19, it starts with the no kids manual, and on 20 with the kids manual, that's where your sample sets start. So there are 2 different versions for both, because we took into consideration all iterations of what might happen. If the husband responds, if he doesn't respond, basically no matter what happens, there's some version in there that can help you. So if your client has a confidential address or doesn't, you know, there's a version in there that fits your case. Of course, if you have questions, we're still always here to help, but know that there is something in there to help you as well. Also, just note, drafting libraries, the newest version of drafting libraries is from March 5th of 2020. If your firm has an older version, you need to update it. You have to go to the drafting libraries website and update that drafting libraries. The reason is because the maintenance cap changed. So in your notices, when you print your summons with notice, the notice guidelines will have the cap in there, and it might be wrong if you have the old version. So make sure you have the most recent and up-to-date version. Your resources are drafting libraries. That's going to be your primary resource for drafting your documents. It basically is a service that allows you to enter all of the information in, and then it just spits out all of the documents. And when I say it spits out all of the documents, I mean all of them. So I'm talking about initial documents, but when you put in the information, it will give all of the documents at the same time. You don't send your mentor all of those documents at the same time. You only send them the initial documents to begin with. And then once you get the response from the defendant or the lack of response, you send them the finals, but it will give you everything all at once. So you have to be discerning about what you're sending to your mentor and when. You'll have your manual, obviously, which is the most important thing you'll have. And then this OCA website, at this point in time, it is not super helpful because it's basically like a riddle wrapped in an enigma. The court's website is changing every day, and none of it actually makes a ton of sense. All the legal services providers will be on multiple calls a week about what it says and what Chief Justice DeFiore's memos mean and how to interpret them. So, you know, if you can figure them out, more power to you. But you know, if you can't, that's not the greatest resource right now, but it's there if you need it. Address confidentiality. This is very serious. As we talked about earlier, a lot of our clients are victims of domestic violence and don't want their partners, their former partners, to know where they live, or don't want them to know what their social security number is. If your client doesn't want her partner to know where she lives, you can do something called getting an ACP address for her. That's something that possibly her justice will have already done, or she may have already done on her own. That's an address in Albany. It's a P.O. box address. and it's for legal documents, and the court will know what that means. You can just substitute her address in for that PO box in Albany in all of the documents, and just make sure that there is no address for her anywhere in any of those documents, because even if it's listed somewhere, later on down the line, if her spouse decides to go to court and get a copy of not just the initial documents and not just the judgment, but he wants the RJI or he wants something else, and you've listed it there, he can get a copy of it. So make sure that if there's an address confidential, it's listed nowhere in any of the documents. If she wants her social confidential, you have to file a motion. It's a very straightforward motion, and that motion, there's a sample in the UD manual. It's an ex parte motion, which means that you don't need the other side in order to file for that motion on the other side, but you don't have to serve the underlying papers, meaning you don't have to serve the affidavit or the affirmation on the other side. So where you're saying the reason why you need this relief, the other side won't see that. So her husband won't see that the reason she wants her social confidential is because he stole her identity, filed false tax returns, and took her tax refund, or he took her credit card and racked up $5,000 in debt, or whatever the reason is that she wants that confidential social. He won't see that information. He'll just see that the judge ordered that it was confidential, and that means that in any papers that you file, you will just put address or social security number confidential. Make sure if it is confidential by order of the court, it's nowhere in any of your papers. Obviously, your mentor will go through those papers before you file them, but just double check. If there's any confidential address or social security number, you want to make sure that it's nowhere in any of the documents. The ex parte motion is on page 75 in the manual for no kids. It's on page 122 if the manual is with kids. So if you need those page numbers, there should be a flag on it if your case is one that needs a motion, and there are a few cases this summer that will need that motion. Also, in terms of e-filing, you can file an ex parte motion through e-filing. You'll file it at the same time as you file the summons, and talk to your career justice mentor about that, but it can be done. Initial documents. So there are several initial documents that you need to file to commence an action for divorce. That's the summons with notice and the accompanying notices. Like a summons in any other case, it notifies the other side of what you're asking for, in this case, an action for divorce. Our summons also lists all of the ancillary relief that you're asking for, which will be if you have kids, custody, child support. If no kids, it'll just be that you're not asking for maintenance and that there's no equitable distribution. The accompanying notices are 3. It's notice of automatic orders, which says during the litigation, neither party can move anything around. So everything needs to stay status quo during the pendency of the action. The DRL 255 notice, which says insurance while a divorce action is pending, and the notice of guideline maintenance. This is a necessary notice, but our clients are not requesting maintenance because in an uncontested divorce, we can't request maintenance. So the notice is required, but in our cover letter, we state, just know, although this notice is in there, your wife is not requesting maintenance, but you do still have to include it. Second one is the verified complaint. This is not served at the same time as the summons, but it's drafted at the same time. It has the same exact relief requested as the summons with notice. That's the document that your client has to sign and that will need to be notarized. The affidavit of service. Note that for divorce actions, the affidavit of service has really specific language. So a lot of affidavits of service like for landlord-tenant cases and like other kinds of cases can be pretty generic. But for divorce, there's specific language that needs to be in there. So use the one that Drafting Libraries comes up with. And the affidavit of defendant. This is what the husband or the partner will sign and have notarized saying that he consents to all of the relief requested in your summons with notice, which is basically nothing unless it's child support and custody. And he'll sign off on that and notarize it, or he won't. But that's what you will be serving him with when you serve him with the summons. The cover letter is not done by Drafting Libraries. This is something you have to type up yourself. It'll be on firm letterhead. There is a cover letter template in the manual on page 120 for the No Kids manual and page 121 in the With Kids manual that will need to be sent over when you send over your initial documents to your Her Justice mentor. The removal of barriers is an antiquated document that says that your client is that both parties are consenting and will remove any and all barriers to their partner's remarriage after the divorce, and that's only if the parties were married in a religious ceremony. Most of our clients are not. They're mostly married in civil ceremonies, and you will see on their marriage certificate whether they were married in a religious or a civil ceremony. You can also just ask your client, but 9 times out of 10 it'll be a civil ceremony and you won't need that extra document, but make sure you double check with your client. And the motion for confidentiality, if you need it, great. If not, great. Just double check with your client again whether she feels comfortable with her address being in the papers. Child support standards chart. You can print this document out at this web address. So make sure you're getting the most recent version. It just says, it's just math. So it just says, if you make this much, this is the number. If you make this much, this is the number. And you'll serve that if there are kids of the marriage. And the last thing is the consent to e-file. If you are going to be e-filing this case this summer, you have to serve this on the defendant because you will need his signature on this document in order to e-file your case. Not to e-file it, in order to e-file the finals. You can e-file the summons without it, but you'll need to have the consent in order to e-file your final documents. Service of process. So depending on your firm, you'll probably just use your same process server. The sheriff's office is serving. And it's like, I want to say it's between $60 and $80. But generally, your firms have their own process server that they like to use, that they know well and that they are comfortable with. So I would speak to your managing attorney's office or your supervisor about how you generally serve papers, and they'll do the service. Just make sure that they sign that affidavit of service after the defendant is served with that summons, the cover letter, affidavit of defendant, and consent to e-file, and the order if there's a confidentiality motion. The server needs to be 18 or older, and they can be anybody who's not a party to the action. That means that theoretically, somebody that your client knows could serve the papers. We only do this in cases where the client wants it. So like if your client says, my sister has a really good relationship with him, I think it would be safer if she did it than having a process server do it. I think if somebody in a suit comes to the door, he's not going to answer the door. Or I think if somebody bangs on the door and he doesn't know who it is, he's not going to answer, things like that. And yes, and there are very specific instructions for if it's somebody that your client knows and it's not a process server on how to effectuate service. But generally, we just do it through a process server, and your firms will know how to do that. But if your client feels strongly that she would rather it be done by somebody she knows, talk about that option with her, as long as it's a safe option. Make sure that it's not, a volatile defendant who, is going to pop off at whoever serves. You have 120 days to serve, from the date of filing of the summons. That being said, there's currently a toll since mid-March, late March. So don't use that though. Don't use it to your advantage. So technically, there is no real deadline because there's a pandemic, right? So the courts are not, you know, if you can't get the document served in that amount of time, they're not marking the case off the calendar right now. But just because that's the case, don't delay in service. If you can get the document served, serve them. And much better to serve sooner rather than later, especially because you want to get the full experience of doing front to back on this uncontested divorce with your client. And the sooner you serve, the sooner you can file those final papers, and the better it is for your firm to you know, finish this up. So we always recommend as soon after filing as you can get it served, do it then. There are three options of what the defendant's going to do after they are served. The first option is that they will sign the defendant's waiver, right? That's the affidavit of defendant that says, I consent to this divorce. I consent to the terms of it. I'm also waiving maintenance. I'm waiving equitable distribution. If there's kids, I agree to pay this amount of child support, you know, whatever. They sign it in front of a notary. Mike's waving, which means I need to read this next thing. What do I do with it? Okay, your next code is TMR 03 for CLE purposes. TMR 03. Okay, so option one is waiver. If they sign it and send it back to you, that's great. And they will also need to sign the consent. So if you get those two documents, fantastic. You draft your final documents, you e-file them, and you wait for your judgment of divorce. That's option one. Option two is they do nothing. They don't respond to you in any way. They don't reach out. You know that they've been served because you have the affidavit of service from the process server after they're served to respond. Again, with the caveat that that time is told right now. So do they? Also, given the fact that they haven't signed that consent, you can't file the finals without the consent. So they don't really have 41 days, but in normal life, they have 41 days to respond. So they could default, right? And then you file the papers without them. So normally you can move forward without the defendant doing anything. If they don't consent, if they don't respond, you can file the papers without them. And you just draft the papers saying they have not responded, etc. And this is how we're moving forward with the divorce. The third option is the most interesting, which is the other option, which is like they will write you a letter and say, I got these papers. I don't consent because I hate my wife and she is awful and she stole half of my life and now I am a broken man. Or they will call you on the phone and say, I want to get back together with her. She is the only light in my life. Can you please tell her that I still love her? Or something to that effect. The other option, which is notice that they've been put on notice, right? So it feels ethically unsound to default them because you know that they are aware of the action pending against them. But at the same time, they can be defaulted because they have not filed a notice of appearance or answered in court in any other way. So her justice policy is generally, if they've said anything to you at all, if they've raised their hand in any way that they're on notice that there is this pending divorce action against them, we take it as that they've contested the divorce, and we file for an RJI and it turns into a contested divorce. If that happens, talk to your justice mentor. We are, happy to, work with you in continuing your representation in a litigated divorce, or we'll take the case back and finish it up for you. But either way, make sure that you let us know if you hear anything from the defendant that's not like just regular court papers, that they haven't, just sent over either a signed document or a notice of appearance, or an attorney contacts you, that they've hired counsel, anything like that. Just make sure you contact us. So once you get some kind of response in one of those three ways, you need to draft the final documents, and you'll draft them based on whatever that response was, either a waiver, a default, or an other, right? If it's an other, it's probably going to be a contested divorce, but one of those two options probably is what you'll be drafting them based on. There are checklists, very helpful checklists in the manual. It's on page 16. For New York County. Now that we're doing things in all boroughs, there's only Manhattan and Brooklyn in your manuals. If you need checklists for Bronx, Queens, or Staten Island, you can reach out to us and we can get you those checklists, because each borough has their own individual, idiosyncrasies and ways that they like things done, and they're very specific. And if you don't turn things in the way they want them, they will kick them back, just based on order or justice mentor before you file anything, if you're doing it in one of those boroughs. But if you're doing it in Manhattan or Brooklyn, make sure you're doing it based on that checklist that's in the manual, because they're very, very nitpicky in those two boroughs. For both a default and a waiver case, these are the documents you're going to need to draft. The note of issue, which is just you saying this court or this case is ready for trial to the court. You're not obviously going to trial, but you're telling them that this case is resolved and that it doesn't need to go to trial. It's ready for the uncontested calendar. Your affirmation of regularity, which is you certifying as an attorney that this case is, ready to go. There's nothing frivolous about it. It's ready for action. Part 130, that's a certification that's required to say that you are certifying there's nothing frivolous about the action. The RJI, which is on the court website. Drafting libraries will print one out for you that's 1,000,000 pages long. You cannot give that to the court. I don't know why Drafting Libraries has that version on it, but you cannot turn in the RJI, which stands for Request for Judicial Intervention. You can't turn that version into the court. I don't know why they use it. And they'll ask you questions in Drafting Libraries. Do you want the long form, the short form, whatever? You can answer whatever you want, because it doesn't matter. You cannot use that version. You have to use this version on the court's website. And there's a specific one for uncontested divorces on there. So make sure you're using the uncontested version and not the contested version. There's also a sample of that RJI in both the With Kids and No Kids manual. The With Kids manual, there's an addendum that's about the kids. So make sure you're filling out both pages if you have a case with kids. The affidavit of plaintiff. Exact same thing as the affidavit of defendant, except your client's filling it out. She's certifying all of the the relief that she's requested in the summons and the complaint. That relief will be identical to that relief that's in the summons and complaint. It'll also be identical to what's in the findings and the judgment of divorce. She'll need to sign that, and it will need to be notarized. Again, it can be notarized remotely. Findings of fact and the judgment are the two biggest pieces of paper in your divorce. Those need to be absolutely perfect. The judgment she may need in the future, everybody is here for. You want that judgment of divorce to be absolutely perfect. So make sure you go over it, make sure there's no typos, make sure that the relief is identical to the relief that you requested in your prior documents, including your summons and your complaint. And the certificate of dissolution is just basic info. It's got everybody's names, dates of birth, social security numbers, addresses, and that's more for the court's use than anybody else's. That's also not in drafting libraries. You'll have to get that on that court website, which is listed here. It's also in your manual, and there's a sample in your manual as well. Poll number 3. Okay, I am very reassured to see that you guys have been listening so closely, but no, you cannot submit the RJI that is spit out by drafting libraries. It is not the correct version. You have to use the one from the court's website. 76% got that one right, so well done. Okay. Ooh. Pardon my wobble. Okay, child support worksheet. As I discussed earlier, this is a bit of a trick. If you have your client's W-2 and her partner's W-2, you have to do the math. If you have that W-2, you can attach it, but you're going to have to sort that math out. You can always ask us for help, but there are samples of that worksheet in your manual. Just note that for child support purposes, you don't take out taxes. So if you are figuring out what your client's and her spouse's adjusted gross income is, don't take out taxes. You only take out FICA, Medicaid, and Social Security tax. That's it. So your regular state tax and federal tax, that's included for purposes of child support. And that trips a lot of people up when you're trying to figure out what the correct amount of child support is. So only also gets taken out. But your state and federal taxes remain in there for purposes of calculating child support. A couple little blips if there is, if your client's on public assistance, and when I say public assistance, I mean cash assistance only. So I don't mean Section 8 housing or food stamps or any other kind of government benefit, only cash assistance. She is not entitled to child support. And by that I mean she does not have standing to ask for child support because the HRA has to get child support on her behalf. They can file for child support with her as the beneficiary, and the way that the government kind of sees it is like, because they're providing her with a benefit, the father basically is paying them back the money that the taxpayer is giving her, kind of thing. So if your client is on public assistance, just know that either she will only get the de minimis $25 a month, or HRA will have to file on her behalf to get the fuller amount. If she's on public assistance, she will be entitled to up to $100 of child support per month. Her for the first child, and if there's 2 kids, up to $200 a month, but no more. HRA will take the rest as repayment. This is a long slide. I know it looks daunting, but if there is a determination, if you're determining what the child support will be, this is the language that will go in your findings of fact about breaking down what the numbers are for the parties. So you don't need to dwell on this right now, but just know this is what the language is going to be in your findings regarding child support, if you do have the numbers for both parties. The key in this whole thing is consistency, right? You want your relief requested and all of your papers to be identical. So your summons, complaint, findings, and judgment should all be exactly the same as affidavit of plaintiff, identical. So, and you can just copy and paste it. It's that easy. I mean, the drafting libraries will do most of that for you, but anything that you manually change, like if there's a prior family court order that you're putting in, know that you're going to have to manually change that in every single document to make sure that it's correct in everything. Because if it's different in one, it will get kicked back. And more importantly, if it's different in the judgment, it can fundamentally change. Assembling your final documents. So, again, a reminder about the checklist. Make sure that it's in the order that the court wants it for whatever jurisdiction you're filing in. So if you're filing in Manhattan or Brooklyn, those checklists are in your manual. If you're filing in one of the other boroughs, make sure you're talking to your mentor about what the order is that those final documents should be in. If there are family court orders, again, you need certified copies. You can't get them right now, so you can risk it and try and e-file the regular copy, or you can wait until they reopen and try and get a certified copy from family court. That's going to be a case-by-case basis, and it's going to have to be up to you and your individual firm on what you think is best. Defective papers notice, the bane of all of our existence. So I don't know what this is going to look like, as this just e-filing started just very recently, but in real life, we get these all the time. People that have been practicing for a million years, we get them all the time. It is not a judgment on you or your ability to proofread or be careful. The clerks that are reading these are people, just individual people, and they all have individual things that are important to them. Some of them care about some things, some of them care about other things, some of them are finicky, some of them don't really care. You can get some stuff through with certain clerks, others are just next level. Like it's really luck of the draw on who's reading these papers and in what jurisdiction you're in. So with e-filing, we've opened a whole new Pandora's box of who's going to be reading the papers and how good of a mood are they in. Defective papers can be for legit reasons, right? Like sometimes it's like you didn't have a certified copy, right? And by certified copy, I mean, like recently we've had a rash of things where like the client will have an order of protection with a different dude from like 2007, right? And she'll say, you know, they run something called a 240 check for every person that has children. So before you can get divorced, they run this 240 check and they see if your name pops up, if you've ever had an order of protection, if you have ever been listed on the sexual offender registry, and if your name pops up anywhere or something similar to your name or your social, they will send out a request like, why is your name on this list? So if your client used a date a long time ago, then they will say, we need a certified copy of this order of protection. And like, how are you going to get that? Like, where is it? Where she doesn't remember where it was, or was it criminal? Was it in family court? What borough was it in? Like, a lot of the defective paper papers notices are things like that, stupid stuff where you're like, why do you care about this? They do it under the auspices of caring about the safety of the children, right? If it's an order of protection and dad was the abuser, they don't want custody to go to dad, right? And so they're saying, like, if dad is known to be someone that commits acts of domestic violence, we don't want custody to be joint custody to both when there's an active order of protection against dad, that sort of thing. But what it ends up being is like, people that have very common names get these things that pop up in sex registries and now have to somehow go into court and explain away these things that have nothing to do with them. So if you get a defective papers notice, don't worry about it. It's not the end of the world. It just means the court's looking for a little bit more proof of things, and we are able to help you with that generally. One note. If you do get a 240 notice, that's not defective papers. That means the court wants you to come in because they've had a hit on either the family court registry, meaning that there's an order of protection, an active order of protection, or a previous order of protection, either on behalf or against your client. And they want you to come in because they have questions about the way that you determined custody in your papers. Make sure you reach out to her justice because we've had some cases in the past that have been kind of difficult where there are issues of domestic violence and the person does not want to be in the same courthouse as their abuser. They don't want to be in the same courtroom as their abuser, and the courts don't deal with that very well. So that's a safety planning issue, and we can absolutely help with that. But if you do get a notice that you need to go to court, make sure you reach out. And thanks for checking in. I want to make sure everybody saw that this poll is up because I only see 41 check-ins, and I think there's a lot more people here, hopefully. I know people were having trouble.
The poll has been closed since it went to 30 seconds, and that's how many people responded.
Okay. Okay, so that's defective papers and also 240. If you have specific questions about your case and 240 notices, feel free to reach out. A note on orders of protection. You do not need to mention them in your papers. If she had prior orders of protection with other people that are not the husband, don't mention them. If she has a current order of protection with her husband, you do need to mention it, and you do need to get a certified copy of it. That will need to be submitted with the final papers. It does need to be listed in all of your documents. And then after you have put in whatever fixes you need to with those defective papers, or hopefully you didn't get any and it just went through, you'll get your judgment of divorce. Hooray, hooray, hooray. You did a great job. And you will do your notice of entry and your affidavit of service. The notice of entry you send to the defendant, letting him know that the judgment of divorce is finalized, and you will enter it with the court. Send the original certified copy to your client, and the affidavit of service plus the notice of entry will go to the court. If you need help with that, there are samples in your manual, and of course her justice mentor can help you as well. So that is your final step, is filing that notice of entry with the judgment of divorce to let the court know that the case is over, and you will do a closing letter to your client with that notice of entry and judgment of divorce that finalizes your relationship with her, and then you will celebrate and hopefully take another case on with us. So once you have given her all of that stuff, you will be all done. As we said, this summer we're focused on drafting those documents. So if your order of operations is a little bit different this summer, that's okay, no problem. We will review things if you can get them done in different orders than we normally do. Usually we do initials first, so get us the initials first and then finals. But if you don't wait to hear back from the defendant to get us finals, we'll review them before. And we can talk about that on a case-by-case basis. And that is all that I have for you lovely people today. Drafting libraries, you have a flow chart. I can't show you the ins and outs today, but there's one for with kids and without kids. It literally is a step-by-step guide, so it looks like it's a nonsensical mess. I created it. I'm not an artist. I don't have that skill set, but it does literally say, like, when you go into drafting libraries, you'll see that the options are like, these are the only options you have, and my options are there. So you'll see where you need to go. We test ran it, and it does work. Although it's not beautiful, it is functional. So use it when you need it. It's in your materials to get you used to drafting libraries, but it is very self-explanatory also. But if you have questions, of course, we're always here. And if you have questions for me now, so let her rip with questions in the Q&A, and I am here to help.
So we have a first question. Question is, my summer program is only 4 weeks. Will it be feasible / efficient for me to take on an uncontested divorce?
Absolutely. So what you should do, I think, and talk about your supervisor with this, but for shorter programs, draft the whole thing. Don't worry about filing and serving and doing all of that stuff. Just draft the papers, because basically what you can get done this summer is doing all of the drafting. What you probably won't be able to get done this summer is getting it e-filed, being able to serve the guy, waiting for his response, and then drafting the finals. So because your program's so short, I would recommend going with just drafting both the initials and finals in one fell swoop, and that way whoever's taking over that divorce from you can do all of those like nitpicky things through their managing attorney's office, and they won't have to worry about the actual paperwork. But of course, go through that with your supervisor and make sure that that's what they think is in everybody's best interest. But I would say go with meeting with your client, drafting the papers, and let them worry about the filing, service, all that kind of stuff. Anybody else have any questions? Anything about COVID specific stuff or remote client contact?
Or if you have any questions about the Her Justice Summer Program or Her Justice in general, please feel free to ask them. I know a lot of you have been on the previous student immigration trainings as well.
Okay, wonderful. Well, I mean, I'm here. My information, I think, is somewhere. But if you want to contact me, my email is cdavis@herjustice.org. But your cases will have your individual mentors. Again, we're working in partners this summer. Make sure you email both of us on all of your individual cases. And as you get your individual case assignments from your supervisors, because your programs are shortened this summer, I would front load the work and don't leave it all till the end of the summer. I know you guys are going to be busy with all of your stuff, and we really appreciate you taking on pro bono work. Now more than ever, it's really the time to do this kind of stuff, and I know it's going to be a really rewarding experience for you. So thank you so much for joining me today, and I hope you guys have a really wonderful and rewarding summer.